Good evening. This bill was passed in a lame duck session a couple of years ago. Started out as a 3-page bill and wound up as an 800-page bill that was dropped on all the legislators' desks. And they had about 2 days to try to digest it. Now, one thing I've learned in working on legislation, if you don't have any expertise in a given field, you're not going to be able to make heads or tails out of the legislation that you're reading. So most of the legislators are now trial attorneys, criminal attorneys, and even the attorneys that I was working with, we were having a heck of a time going through all 800 pages. And again, not all 800 pages were amended, but you had to go through them all to find the little nooks and crannies where the changes had been made. Now the gist of it is, this bill will abolish bail on January 1st of next year. And a few months ago, as I was looking at the run-up here, I started thinking, wait a minute, equal protection under the law, that means everyone in every jail in Illinois, their bail will be abolished. I've got over 600 prisoners in the Will County Jail, and I think 60 of them are charged with murder. And the best we'll be able to do on January 1st is try to have a hearing to hold the people charged with the forcible felonies with mandatory prison for another 90 days. That's the longest you can detain anyone under this new bill. Think about the Cremo case in Lake County. 90 days would be the maximum they can hold him before. If they don't give him to trial within 90 days, he has to be released. Now there can be some restrictions like an ankle bracelet, things of that nature. I'll just call your attention to a couple weeks ago in Chicago, a murderer on an ankle bracelet murdered the person who witnessed his first murder. So in Will County, there aren't any murderers on ankle bracelets. They're in the Will County Jail. And that's, the Constitution of the State of Illinois says that all persons shall be bailable. So it's my position that in order to do this, there has to be a referendum to change the Constitution in order to abolish bail. The crime victims obviously are the beneficiary of bail because they have a right under the Constitution to be reasonably protected from the accused throughout the criminal justice process. They have a right to have their safety, and their family's safety considered in denying or fixing the amount of bail, determining whether to release the defendant, and setting conditions of release after arrest and conviction. And that's a pretty sacred principle in our law. You know, our forefathers did a lot to make sure that we put a lot of rights in the Constitution for the arrested person. And nobody ever thought that anyone would pass a law like this, which would disregard the law-abiding people. But it happened, and it's in the line to take effect on January 1st, as I said. And I'm working very diligently right now on trying to find ways to stop it. But one of the things is to get the public energized, because there's an election in November, and we can all demand that anyone running in November will pledge to repeal this bill. The city of Chicago is the most violent city in the country. Not per capita, but gross numbers. The city of New York has 3 times as many people as Chicago. Last year, Chicago had 800 murders. New York only had 450. Last year, there were 1,800 carjackings in Chicago. New York had 500. And they have 3 times the size of Chicago, if that doesn't give you a perspective on what we're dealing with here in Illinois. Now, in Will County, we've been very fortunate. When they come, the gang members have come here. Our law enforcement has been phenomenal. We've made the arrests, we've got the indictments, and they're awaiting trial. Once that happens, what happens? The word gets back. They stop coming. Mayor Lightfoot was just quoted recently. She broke ranks with her fellow elected officials up there and said, violent offenders need to remain in jail until their trial. She said, if you let them out, they terrorize the victims, and they become emboldened, and they commit even more crimes. Well, that's exactly what every normal person says. So I give Mayor Lightfoot credit for that. The legislation itself, it has a list of things, different crimes where you can seek detention. The main one being forcible felonies that have a mandatory prison sentence But then the hook is, I have to prove that they're a threat to a specific identifiable person. Well, let's look at this as murder and attempt murder. In murder, you've murdered the person that would have the most fear of you. So I won't be able to meet my burden. On attempt murder, the person survived, so that would be my victim. I'm going to detain you. Now, every person who is detained is going to demand trial on day one and run that 90 days on me. I don't have the manpower and woman power in my office to meet that kind of demand where everybody that gets detained is demanding speedy trial in 90 days. And again, look at the Cremo case. Can you imagine the amount of time it's going to take to put that case together? All the forensics, all the witnesses, all the videos, all the electronics. It's going to be an enormous task. So, criminal history also is irrelevant. So, when I talk about the mandatory prison, you could have a guy that did 2 armed robbery stints in prison and then comes out and does this 3rd crime. And then, let's say it's a robbery. There's a list of forcible felonies that don't even qualify for detention. Burglary, robbery, arson, kidnapping, 2nd-degree murder, intimidation, aggravated battery, aggravated DUI, aggravated fleeing and eluding. Drug offenses. If I had enough fentanyl to kill everyone in the United States of America, under this new law, I couldn't detain that person for 1 day. If that's not the most absurd scenario you've ever heard, I can't give you any more. I just sent somebody to prison for 20 years for possessing fentanyl in Will County. When he was arrested, he went to Will County Jail, never left. He's going to prison for 20 years. That's the way it should be. But you let a cartel guy out, you don't lock him up, you think we'll ever see him again? Not a chance. And that brings me to the next major problem with this bill, with the 90 days. If the person is released after 90 days, I've never seen this. The judge is told he can't seek a warrant if the guy doesn't appear in court. We have to get what's called a rule to show cause. A rule to show cause, you can ask Eric, he does a lot of civil cases. It's just a piece of paper saying, please come to court. Well, I can tell you right now that your deputies that you pay to protect you here, they don't have the time to be running all over the place, serving rules to show cause on people. First of all, they're not going to answer the door, and the officer will have no ability to forcibly enter like he would on a warrant. So these things probably, for the most part, either they're not going to even get a temp service, or they're not going to get served, so we're going to have this buildup of offenders out there who are evading prosecution. And maybe the only time we get them is if we arrest them on a new charge. Now let's get to misdemeanors. This is just, you're not going to believe this, but the police can't arrest a trespasser anymore. You can't detain a trespasser. When the people who trespass get wind of this, what do you think they're going to do? They're going to come at us in a crowd mentality. And then one of the interesting criteria for the officer to even give the person a summons, it says upon review of a proper ID. Now, how many of these people, say if they're homeless, don't have an ID? It doesn't tell you what to do if they don't have an ID. So if a guy comes to your home and he's harassing your family and the officer comes and says, get out of here, you're breaking the law, it appears he could cuff him and drive him down the street, give him the summons, but then he's got to let him go. He can't take him to jail, and he can't take him in front of a judge. So there's no enforcement. I mean, where that will lead, I can't even begin to imagine. So, common sense was not something that was really in play here. The rule of show cause, too, we have to serve them within they have to be served at least 48 hours before the court date. So an officer could be out there looking for a guy for a week and catch him on the 47th hour. Well, now he's got to go back and get another piece of paper, and he'll never find the guy again. That's obviously a technicality, but it should be applied in criminal cases. There was a carjacking on Diversity Parkway in Chicago, and the individual made the mistake of fleeing to Will County. And so we arrested him in Shorewood, and there's a principle under the law that your crime is not complete until you made a full escape. So I approved charges on that case, and he's in the Will County Jail on $1 million bond. Had he been arrested in Chicago, he'd be out right now carjacking as we speak. Now, I see smiles. It's sad that if you want to know what the state of Illinois is going to look like if this law goes into effect, look at the city of Chicago. And I've been doing this since 1982. I was sworn in as an assistant state's attorney. I'm in my 7th term as state's attorney, and I'm really proud of what we've been able to accomplish here. We have a great balance between aggressive prosecution of violent offenders and then extending that hand to the person who needs some help, mental health, drug addiction. We have Redeploy Illinois. Has everybody heard of Redeploy Illinois? It's a great program. We offer young offenders, property offenders who have been to prison before and are on their way back. We offer them job training and a job with a local business. And if they succeed, we all succeed. We're not paying 30 grand for them to sit in a jail cell. They're earning a wage, they're paying taxes, they're renting a place to live, they're buying goods in the community, and hopefully on their way to a better life. And I've talked to some of these young people. Many of them got arrested out of high school, never had a chance. It was a downward spiral right from the beginning. And the pride they show in their new job, it really, really is an incredible program. So, you know, we can be proud that we are aggressive against the violent offenders, but at the same time, we extend a helping hand to those that deserve it. This particular law, though, is something that, you know, we've never faced before. And I want just to make sure that everybody understands that it's real. And, you know, the release of the prisoners from the jail, when I know that, you know, victim services is one of our best aspects of our office, and we stay in constant contact with the victims. There are victims who are afraid right now when the individuals are locked up. What is that fear going to be like if they're released? And I mentioned the guy on the ankle bracelet. What did he do? How do you get more brazen than going and hunting down the person who's the eyewitness on the person, on the murder that you committed that put the ankle bracelet on you? It's just mind-boggling. So, again, we can get the word out by talking to each other. I'm trying to get out and make sure that at least people are aware that it's coming and do everything I can to stop it. And if anybody has any questions, try to answer it.
State's Attorney,
yes.
Thank you very much for being here. House Bill 3653, has it passed already and it takes effect on January 1st, 2023, or
yes.
is it looking to be passed on January 1st?
It was passed as part of the so-called, what's it called, the Safety Act, or I forget what it was called. It was, you know, whatever. This was delayed. Some of it went into effect. This was delayed until January 1st. And we're supposed to be able to try to work out some of the kinks, but there was never any legitimate effort to accept our criticisms.
So we have enough time. What can we do as trustees to help you, and what can the citizens do out there to help you in achieving the goal of helping stop this?
Again, as voters, we need to work with the people running in November and make sure that this is the #1 priority. I mean, this is life and death. I will not be able to protect the people of Illinois or Will County with this new law. It'll be a travesty. And let me just give you another sample of what went through. This went into effect last January. The use of deadly force by a policeman. Now, they added in that the officer, when he's in a position where he may have to use deadly force, has to consider how old the crime is, how recent was the crime, and can the person be arrested later. Now, I've been reviewing the use of deadly force in Will County since 1992. And everything you see on TV isn't true about the average police officer. I've not had a single police officer since that time exceed their lawful authority in the use of deadly force. Now, you know, you watch TV and you think they're doing it every day around every corner. That's not the case. Will County is a good cross-section of the United States. We've got all aspects of society here. So we're not just, you know, a country club community. We're a good reflection on the United States of America, and that's a hell of a thing to be able to say. And most of these officers, probably 70% of them, didn't fire at their first opportunity because they did not want to have to use deadly force. But this new law, and I've talked to officers, and many of them aren't even aware of the change in the language, but it gets worse. When you used to be able to use deadly force if there was an imminence in the use of deadly force against you or another, or there was a possibility of death. And the new law takes another step in defining imminent. And they say imminent is not merely a fear of future harm, no matter how great the fear, no matter how great the likelihood of the harm, but it's one that, from appearances, must be instantly confronted and addressed. So if an officer saw a triple homicide as he's driving up in a squad car, it was a few hundred feet away, and the perpetrator took off running, well, at that point, I'm not sure how to interpret this, but it looks like he's not instantly in danger at that point. Now, he could be running towards an old folks home, but this says you can't consider future harm, no matter how great or how likely. Now, that just sounds ludicrous, does it not? That's what it says. So we don't have any court review of this statute, what it exactly means, but I think most officers are being trained. If one of these offenders is running away like that, you can't shoot him. You can't use deadly force, even though you know that that person just killed 3 people and he's a danger to everyone that he's running towards. So, again, we fought like heck to get this amended and get that language changed, and we were unsuccessful. And as you see in Chicago, the Chicago police chief has a rule now with not pursuing, not chasing offenders in the more minor cases. We just need to get things back on track. People with common sense need to step up and say, we're not going to take this. This is irrational. But again, this is so dangerous that we're all flesh and blood. And I don't know if the people who wrote this, a lot of them did not understand what they were voting for, and that's why it got passed.
So House Bill 3653, every House bill there's a mindset behind it, right? I mean, there's a reason why it got initiated in the first place. Is it the cost per inmate that initiated this, and we don't have the finances as the state in all these places to do that? Or what do you think the mindset was behind this bill and its initiation?
It's just an aversion to offenders being incarcerated.
It doesn't go back to cost, though?
What's really ironic here is the Illinois Constitution deals with no bail. And it says that people who are held without bail, the cost of that is a transfer to the state of Illinois. So technically, the local authorities would get a benefit here in that when they are detaining somebody during that 90-day period, that cost could be transferred back to Springfield. I don't think the legislators realized they were doing that, because that's the last thing they would do usually if they're paying.
I was just trying to figure out why they would even do such a thing. It does, like you said, it sounds crazy that they would even do this, and I'm just trying to dial back to understand why or where they got started.
Well, I read off the charges that I can't even detain. Does that make any sense to you? Those are dangerous people. And then if they had prior criminal histories, they could have had an armed robbery and a murder in the background. Those charges I read off, I still can't detain them because that's irrelevant to detention. But it's not irrelevant to detention now because common sense is in play. We use rational thought processes to analyze the danger of a person so that we can make the bond significantly enough so that he or she can't harm anyone during the pendency of the case. And let me just finish up here, because this isn't a political issue. This isn't, I'm a Democrat, I'm working with Bob Berlin, who's a Republican, and we're both fighting like hell against this bill. But let me just quote Mayor Lightfoot, and I think this is important to show that it's not Republican or Democrat. We're all citizens of the state of Illinois. She said, residents in our community are also entitled to safety from dangerous people. So we need to keep pressing the criminal courts to lock up violent, dangerous people and not put them out on bail or electronic monitoring into the very same communities where brave souls are mustering courage to come forward and say, this is the person who is responsible. That's the biggest problem in Chicago, is that the gangs intimidate to the point where the witnesses and the victims are terrified. They won't come forward, they won't testify. And there's just an article in the paper now, something about the arrest rate is down to 12% in Chicago, and that's why. We don't have that in Polk County. She continued, if we hold violent, dangerous people accountable, we will see a significant drop in violence in our city. That's common sense, that's what we do here. But when you've got somebody who's accused of murder, attempted murder, rape, kidnapping, carjacking, as is now, these people are walking the streets right now in our communities because our criminal courts are not doing their job and taking into consideration the danger to the community. How prophetic by the mayor. She said that on June 6th. But everything she's saying here is going to be ignored by this bill. This bill does exactly the opposite of what she just said. How ridiculous. But I never like to say never. Just for example, Drew Peterson would not be in prison right now if I was laboring under this law. I never would have got a conviction. He was on a $20 million bond during the whole pendency of that case. That couldn't exist today, could it? So if you want an example of a psychopathic killer that would be out on the street because of a law like this, there's one. So again, we just all need to get very active and talk to people. Obviously, a number of people in this room are elected officials, so you're plugged into how things work, and we just have to start emailing and talking to the candidates and make sure they understand what this is. There's probably some legislators that voted for this that really don't know some of the fallout that's going to happen. So,
can I ask you a question?
Yes.
Why can't we make the people who make these rules, let them go out in the street? Let them protect the streets. Right now, you've got the policemen to where they're handcuffed. So how does anyone expect them to do their job? And why would anyone stop? We also have the one where if it's $999, you can't arrest them.
Right. Well, that's a whole different ballgame. Their standards, the standards in Cook County in the last 6 years have been terrible. So, down here, if somebody walks into a Walgreens and I can prove that when they went in there, they had the intent to commit a theft, that's not retail theft, that's burglary, class 2 felony. So you hit a couple people with burglaries for bringing a bag into Walgreens and start shoveling the stuff in, word gets out, they don't come back. So there's a huge deterrent effect there too. But again, we won't have a deterrent effect if I don't have the tools. My hands are going to be tied, the police hands are going to be tied, the judges' hands are going to be tied by this law. Again, like I said, I'm very optimistic. I'm working on something to try to stop it. But as a backup plan, we've got to get the legislators who are running to acknowledge this is an anathema, and it will endanger every man, woman, and child in the state of Illinois the moment it goes into effect. So we all can do something about it, and I'm optimistic. I know Homer Glenn gets things done, so let's see what you guys can do. Thank you.
Thank you, sir.
Thank you.